Hello, everyone. Welcome to our monthly S&O IP webinar. Today, our topic is navigating the landscape of innovation protection, patent registration in China. My name is Liliana Zhang. I'm a patent agent from the Beijing office of S&O Intellectual Property. I'm very excited to introduce myself to you all. I have been working at S&O for more than 10 years. Over the years, I have gained extensive experience in this area and have helped many clients protect their intellectual property rights. Thank you for the opportunity to address you today on a subject that is not only pivotal to the growth of innovation, but also to the economic fabric of nations, patent registration. Specifically, I will detailedly introduce patent application and examination process in China. China Patent Prosecution Highway and Design Patent Protection via the Hague system. If you have any questions during the webinar, please feel free to submit them via this email, l.zhang@so-ipr.com, and we will answer them in the end of our presentation. Now, part 1, general introduction to patent application and examination procedure in China. In the vast and competitive area of global commerce, intellectual property rights serve as both a shade for creators and a bridge to international markets. Within this context, understanding the patent registration in China becomes paramount. China offers a landscape rich with opportunities for those who can navigate its IP. Now, let us see the patent types in China first today. China patent law recognizes 3 main types of patent: invention, utility model, and design. Each serves a distinct purpose and comes with its own set of requirements and benefits. The first, invention patents. Invention patents protect new technical solutions relating to products or process and are typically viewed as the most significant form of patent protection. They offer the longest period of exclusivity, 20 years from the filing date. Second, utility model patents offer new technical solutions that possess practical accessibility and represent an advancement over prior art. These patents have a shorter terms, usually about 10 years from the filing date. Then, design. Design patents safeguard the products such as shapes, patterns, colors, or the combination thereof. The protection duration for design patents is generally 15 years from the filing date. The duration of protection for a design patent has been extended from 10 to 15 years, bringing it in line with international standards. This change ensures that creators of design can enjoy a long period of exclusivity and protection for their intellectual property. Then, let's now take a look at the patent examination process in China. The journey of a patent application in China is a structured one, involving multiple steps. Here's an outline of the process. First, filing. The applicant submits a patent application to the patent office in China, which must include detailed descriptions, claims, drawings, and abstracts of the invention. All submissions must be in Chinese. And as patent agent, we typically handle the translation work for applicants to ensure that the submitted documents meet the requirements of the patent office and protect the applicant's technology to the greatest extent possible. Preliminary examination. Patent office conduct a preliminary check to verify that the applicant meet formal requirements, such as correct documentation and complies with legal provisions. Substantive examination. For invention patent, a substantive examination is offered where the invention's patentability is assessed based on novelty, creativity, and practical applicability. This stage does not apply to utility model and design, which are granted without substantive examination upon passing the preliminary check. The basic standard for patent examination in China are as follows. Novelty. The invention or utility model must be new, meaning that it is not identical to an existing technology before the filing date. Inventiveness. The invention must have prominent substantive features and represent a significant improvement compared to the existing technology. Practical applicability. The invention or utility model can be manufactured or used, and it can produce effective result. Okay. Then, publication. Once an invention patent passed the examination, it is disclosed for public. Then granted right. If the patent meets all requirements, Patent Office grants a patent and issue a patent certificate to the client. The last, maintenance fee. To maintain the patent's valid, annual fees must be paid after granting the patent right. Applicants can decide for themselves when to stop paying the fees. In conclusion, the Chinese patent system, with its clear classifications and structured examination procedures, provides a pathway for creators to protect their creations. Okay, we continue our exploration of patent registration in China by shifting gears into a higher velocity pathway designed to accelerate the journey of patent applications. The China Patent Prosecution Highway. We shall mention it CPPH as following. Let us now study the specifics of the CPPH and the advantages it represents over traditional application and examination procedures. In an area where innovation knows no bounds, the conventional path of patent application proceeding can sometimes seem as adequate as the inventions they aim to protect. Recognizing this, China has introduced the CPPH, a program that mirrors the Patent Prosecution Highway, initiative found in many other countries. The CPPH is an IP accelerate tool that allows applicants to expedite the examination process for their patent applications in China based on positive examination results from equivalent patent applications in other countries. We can see many benefits of the CPPH compared to traditional process. 1. Reduce time to grant. One of the most immediate benefits of the CPPH is a significant reduction in the time required to obtain a patent right. While traditional patent examination in China can take several years, the CPPH can lessen this duration, making it particularly appealing for techniques with a short product cycle, or those requiring rapid market entry. Second, enhance efficiency. By leveraging the prior art search and examination outcomes from corresponding patent office abroad, the CPPH eliminates repetitive work. Then, increased predictability. With the CPPH, applicants gain a clear projection of their patent's journey in China right from the onset. This predictability is invaluable for strategic planning, allowing applicants to make informed decisions about their IP portfolio and commercialization strategy. International trade sensitivity. For international business, the CPPH serves as a bridge, smoothing over the difference in patent process between countries. The last, strengthen the international cooperation. As a member in the global PPH program, China's adoption of the CPPH underscored its celebration with the international IP community. This collaboration promotes a harmonized approach to patent examination, reduce the barriers to international trade, and encourage a unit front in protecting and encouraging global innovation. Now, China has created CPPH cooperation with over more than 20 countries and regions, including the United States, Europe, Japan, South Korea, Russia, and others. Those cooperative networks cover major overseas markets where Chinese companies and companies abroad seek to go global, providing applicants with a fast track for patent examination in those countries. The CPPH is a high-speed way for patent applications that offers a quicker route to patent protection compared to the conventional route. As we conclude our disclosure on invention in registration in China, we turn our attention to another topic, design patent protection via the Hague system. This international framework offers a harmonized solution for securing industrial design rights across multiple countries, including China. Let us explore the guidelines for applying for design patent through the Hague Agreement. highlighting its advantages and outlining the steps required to navigate this global route to Chinese registrations. Here's how you can leverage the Hague system to protect your design in China. The first, ensure that your design meets the provision of protection. In China, this includes being new and having an original aesthetic character that gives a different overall impression on an informed user. Then, choose China as a design deposit country. When submitting your industrial design applications through the Hague system, select China as one of the countries where you wish to deposit your design. This action will extend the protection offered by the system to China. Prepare required documentation. Submit clear representations of your design, including drawings, photographs, or samples, along with the application form and any required fees. Ensure that the documentation accurately reflects the features of the design that are novel and deserve protection. Locate a recognized industrial design office. You must fill your application at a design office recognized under the Hague system. This can be done directly with WIPO or through your local design office if it particulars in the Hague system. Obtain international registrations. Once your application is accepted, an international registration certificate will be issued, indicating the protection of your design in China and other designated countries. Complete these local requirements. Although the Hague system simplified the process, some countries, of course, including China, may have additional requirements. Stay informed about any specific regulars or procedures that must be followed to maintain your design patents valid in China. Maintain your design patent. Like all patents, design patents require a maintenance fee to keep them active. Be prepared to pay the necessary fee according to China's patent laws to sustain your design's protection. The Hague system significantly reduced the complexity and cost associated with obtaining design protecting in multiple countries. By using this system, designers and companies can efficiently protect their innovation design in China while enjoying the convention of a centralized application process. In conclusion, the Hague Agreement presents a strategy and efficient pathway for design of patent applications seeking international protection, including with China's vibrant and growing market. As we wake up our discussion on patent registration in China, it is my hope that this insight into the Hague system further illuminate the path to safeguarding your creative works in the global area. Okay. I hope this presentation provided valuable insight into navigating patent registration in China, because Understanding the process and including strategy tools like the CPPH and the Hague system are essential for effective patent registration and protection strategies. Okay, let me check now if we received any questions during the webinar. Oh, this one? Oh, thank you, Tammy. This question is, I understand that there is a patent prosecution highway in China, yeah, which you also mentioned can be faster than traditional patent application. How much faster exactly is it? Oh, this is a good question. According to the date from the patent office, the traditional examination process for Chinese invention patents was about 2 years, While in the PPH programs, applicants can request an accelerated review by the subsequent patent office after review a positive examination result from the first patent office. The period from PPH request to case enclosure is about 11 months to 1 year, which is significantly faster than a traditional applicant. Hope this answer is useful for you. Now, okay, thank you for your attention. Then, if you have remaining questions, please don't hesitate to reach out to us. Rest assured that we will provide a detailed analysis and response upon review the details of your question. Okay, thank you.